Hello and welcome to today's Eversheds Sutherland webcast about face the legal implications of using biometric information. If you have a question during the broadcast, please submit them via the Ask a Question text box on your viewing console. CLE credit is approved for this webcast in California, Georgia, New York, Nebraska, and Texas, and is pending in Illinois and Virginia. If you would like to receive CLE credit for this webcast, please download and submit the CLE sign-in sheet and evaluation forms. We will provide you with a confirmation code for you to enter on your sign-in sheet. This webcast is being recorded and the final version will be posted to the Eversheds Sutherland website within the week. I will now turn it over to Frank Nolan, counsel at Eversheds Sutherland.
Thank you. To paraphrase Jim Carrey in The Truman Show, good morning, good afternoon, and good evening, depending on where in the world you're dialing in from today. As you just heard, my name is Frank Nolan, and I'm in the New York office of Eversheds Sutherland. I am pleased to be joined today, at least virtually, by my colleague from the Manchester, UK office of Eversheds Sutherland, David Cook. Good afternoon, David.
Hi, Frank. Good to join this call from Manchester.
So, as the title suggests, today we'll be discussing biometrics in the law. Biometrics is a rapidly developing area of the law with implications for industries of all types and companies of all sizes in nearly all legal jurisdictions. This presentation, by its nature, is intended to be an introduction and an overview of some of those issues. We will cover basic information and background, followed by a discussion of some of the legal issues and important laws in the U.S. and in Europe, with a focus on litigation risk and compliance. During the presentation, as you heard, if you have questions, please type them into the browser and we'll try to get to them at the end of the webcast. If we run out of time or are unable to get to everyone's questions, we'll be happy to contact you individually following the presentation, and please also feel free to reach out to us afterwards with specific questions. We also encourage you to review the firm website for more information on biometrics in the law. Two additional housekeeping notes. As you heard, first, we'll provide a code for CLE credit during the course of the presentation, and you can just write that code onto the CLE worksheet available on the webcast browser. And second, in the spirit of the season, we will have a few Halloween trivia questions throughout the discussion. If you know the answer, please email one or both of us, and if you get it right, we'll send you some Eversheds Sutherland swag your way. Please don't type your answer into the browser, though, and just shoot us an email with that. Our first Halloween trivia question, when the Peanuts gang went trick-or-treating, what did Charlie Brown receive? A, rocks, B, candy, C, sticks, or D, apples? Again, just email one of us with the answer, and we'll get back to you. So what are biometrics? So let's begin today by outlining a scenario that is not far off in the future by any stretch. Let's say you decide you want to attend a baseball game. This is how it could unfold. You leave your home for the game, and you lock your door using a scan of your retina or your fingerprint without using a key. You get into your car, you start the ignition without a key or a fob, instead using the sound of your voice. You drive to the stadium, and you don't stop to get a ticket at the parking lot because the camera at the entrance to the lot recognizes you and immediately bills your credit card. You breeze through security because a camera scan of your face is run through a database and it determines that you are not a security risk. You don't stop at the ticket counter because scanners inside the entranceway to the stadium recognize you by the way you walk as a season ticket holder of Seat 3, Row 42, Section A. Once inside the stadium, you look up at a screen and you see an advertisement that is directed at you because facial recognition technology has identified you as belonging to a certain demographic group, and it selects products that you may be interested in. That leads you to go buy that advertised food or drink, and you do so without getting out your wallet because, again, the software at the vendor recognizes you and charges your credit card. Finally, you find your way to the seat without taking out your ticket to show the usher, and you sit down with the satisfaction of knowing that the risk of credit card theft for your purchase of the parking space, ticket, and food is lower than if you handed your card over to make those purchases. You also know that your home and car are secure because only you have the ability to access them. All of those events, or non-events, from the time you walk out your door to the time you take your seat with beer and hot dog in your hand to watch the Yankees or the Cubs lose in the playoffs, are all made possible through the use of biometrics. These examples of using biometric data to verify or identify all exist in some form or fashion already, and really are at the tip of the iceberg when it comes to this rapidly developing technology, which generates revenue in the tens of billions of dollars per year, and that figure is growing. David?
So on this slide, what we've tried to do is highlight some features that can be considered biometric identifiers, but this list is growing all the time, and some of them are quite interesting and unbelievable. So you can broadly divide biometric identifiers into two categories, those that are biological and those that are behavioral. And often, more sophisticated biometric systems now mix the two together, so you might get one from one category or two from the other. But a person's face and a person's fingerprint are biometric identifiers, and we see that in terms of smartphones now. But hand geometry and how the hand is set up is another example of that. Iris scans are something that we hear a lot about in my day-to-day life. I've never seen that, but it's another common identifier. But on the right there's some fairly interesting ones. Voice is an example of a behavioral biometric identifier, and we see that with some banks now recognizing that. But the way in which we hold our phone, the way in which we might put in our password, not the password itself, but the manner in which we slide our thumb across the screen of our smartphone may be an example of a biometric identifier. It may be that as you walk to the what we call a cash machine, I guess many of you will call it an ATM, the manner in which you walk, your gait, is a behavioral identifier. And for reasons that we'll come on to and we'll explain later on, this is no longer a binary identifiable feature like a password is. It's not right or wrong. It gives a percentage that the person who is displaying those features is the person that you're looking for. So the gait plus the face plus the fingerprint may give an 80% accuracy that it's the person you're looking for, and therefore your risk tolerance means that they're let through on the system. And so this list is growing all the time. Before we started the call today, we were discussing that we've read somewhere that odor, body odor, is a bit biometric identifier that we may see in future. That sounds a bit disgusting to me, but maybe it's something that will be added to the list to give accuracy. The biometric identifier is frequently converted into a template, and the biometric template is the element that's stored by the provider. So the provider doesn't necessarily store a person's fingerprint or what their face looks like, but the fingerprint or face that the system looks for is reduced by an algorithm or a treatment into a template, and it's a template that's stored, which may be a security feature. So lots of things are biometrics. Is it new, though? No, it's not new. If we move on to the next slide, Frank, we'll see why. So 31,000 years ago, caveman's hand. Cave paintings often had handprints in there as unique identifiers. The handprint wouldn't be as detailed as to show a fingerprint, or perhaps a fingerprint that you could identify as compared to somebody else's, but it would give an indication of the person who'd made the cave painting. 15,000 BC, fingerprints dipped in wet clay would be used to record the identification of a person who'd consented to a business transaction. These are 1,500 BC, that is. These are certainly historic. The next one on the list there is a case. So the People v. Jennings, 1912, murder case involving an intruder who gained entry via a window. The intruder left his fingerprint at the scene. which was kept on file, and Mr. Jennings was found, and his fingerprint was matched to the one on file. So 1912, that's a long time ago. Now, this is not biometrics for banks. This is not biometrics for some necessarily some sophisticated financial services or high-end reason, but murder investigation, a person convicted and presumably went to prison for a long time, if not life. It has an importance. That's 1912. 2013, then, this is probably going to be public consciousness, and most people on the call will recognize this. Apple introduced Touch ID, and biometrics was then popularized as a consumer security tool. What's interesting with this is it made it very easy for the users. Users often press the home button on their phone all the time in normal use of the phone, and it converted the home button into a fingerprint scanner, which meant that people were giving their biometric information without really having to do anything different with their behaviors. People are often concerned about privacy and security, and Apple, in the iPhone design there, had the fingerprint information encrypted and stored securely on a separate chip within the phone. It's supposed to never be stored on Apple servers, and it's said that it's never backed up to the iCloud. So that's a really modern example, and it's one that is probably tip of the iceberg with what's going on. So next slide, please, if you don't mind, Frank. So we've got some examples. First one, Madison Square Garden used face scanning technology on customers. It's supposed to be for security reasons. That was March of this year. We've seen one recently. I live in Manchester, from Liverpool, live in Manchester, and we saw an example where local shopping centre was using facial recognition technology, and there was a bit of an outcry there about the privacy of the people going in. Next one there, facial scans at US airports, and again, this was supposed to be a security thing where it prevented people from overstaying on their visas. Again, privacy concerns. You're going to see a theme here, privacy concerns. Next one we've got to show you about. So banks are increasingly using fingerprints and faces as a way to identify users and verify that they are who they say they are. And the reason for that, this is quite easy to think about in this way. We see about breaches all the time. We see about hacks all the time. We see about data lost. So passwords perhaps aren't as secure as they should be. Social security numbers, addresses, these are all things that are publicized after breaches. And so banks are increasingly looking for fingerprints, faces, biometric features. These are things that can't be lost in the same way. They can't be reproduced by criminals or intruders. So we often see combinations of the biometric feature with something like a password. Next slide, Frank.
So
US flag there. I'll hand back to you.
Appreciate that. Now we'll talk about the Illinois Biometric Information Privacy Act, known as BIPA or BIPA, which is at the forefront of this area of law. This law was enacted in 2008, and it prohibits a business from collecting or receiving or storing or using biometric data without complying with certain notice and consent requirements. This statute covers everything from fingerprints used by an employee to scan into a time card system or unlock a restricted area at work, to facial or voice recognition software used by some of the largest and most sophisticated companies in the world across nearly every industry. It's noteworthy what BIPA does not consider biometrics: writing samples, written signatures, photographs, human biological samples, demographic data, tattoo descriptions, physical descriptions like height, weight, and eye color. Now, what's interesting is that despite the prevalence of biometric data in use by so many companies of all sizes for quite some time, this statute was somewhat dormant for about 7 years. Then, in 2015, some enterprising plaintiffs' attorneys realized that it could be an ideal tool to use in the class action context. So, over the last 3 years or so, hundreds of class actions have been filed in Illinois state and federal court, as well as a few federal courts in other states. And we'll talk about some of the more important BIPA decisions in a few minutes. And this is some of the language of BIPA and highlights some of the notice requirements, but not nearly all of the statutory requirements of the law. The basics of BIPA are as follows. Number one, it requires informed consent of the individual whose information is being collected. It prohibits the collecting party from profiting from that data, although how that is defined is something that the courts have not really addressed yet in any depth. 3, it restricts if and how disclosure of the data can occur. 4, it creates guidelines and rules as to the protection and destruction and retention of that data. And 5, it creates a private right of action. And that's the important part, I think. You'll see here why plaintiffs' attorneys are so thrilled to have sniffed this law out. The statutory damages provisions are fairly severe when considered, particularly when considered in the context of a class action. We've got hundreds and potentially even thousands of class members. You've got $1,000 for negligent violation, $5,000 if the violation is reckless or intentional. So each time you use or disclose that data, it's a separate violation. So if you collect, you use, and you store an individual's data a single time without consent in violation of BIPA, that's $3,000 if it's negligent, and $15,000 if it's intentional. If you disclose it to a third party, it's another violation. If you repeatedly disclose it or repeatedly use it, those are each separate violations. Now you multiply those numbers by a large class population, throw in statutory attorney's fees, and you start to see what is plaintiffs' attorneys frothing at the mouth. Now we'll discuss the standards for stating a claim under BIPA as they exist so far in a few slides. But I think it's important to note that I know of no examples of compromise of biometric data in any of the class actions filed under BIPA. So in other words, plaintiffs' attorneys have so far relied on BIPA because they've been unable to bring common law claims, as is often the case in data breach class actions, where other forms of PII, such as Social Security numbers, are accessed or stolen. The encrypted and secure nature of the majority of biometric information, as David was just talking about, which is particularly used by more sophisticated companies, that should dramatically mitigate the risks attendant with breaches. But on the other hand, courts do not all require a showing of harm or impending harm, at least don't use the same standard as each other, and a violation of BIPA and potentially other similar statutes enacted in the future may be enough to state a claim. Again, we'll talk about this in a few minutes after David tells us a bit about the GDPR.
So what we have here listed are two pieces of European legislation. I'm not going to give you a lecture about European law. However, it's probably worth bearing in mind that regulations have got direct effect. So the GDPR came into law across the EU on the 25th of May 2018, and the member states of the European Union didn't have to do anything for that to be so. A directive is an example of European law which has to be transposed into member state legislation, and the revised payment service directive has been on the block for some time and is being transposed across the different European member states at different times. So it hasn't had quite the impact that the GDPR had. One, because in a lot of ways it doesn't have as much of an impact, but two, because it didn't come in on the same date across all of Europe. If we go on to the next slide, though, I imagine you guys will be fairly sick of hearing about the GDPR now. In Europe, we certainly are. However, in a biometrics context, it's worth considering. So let's go back to basics for a second. Bear with me, indulge me on this. The GDPR covers the use by organizations of personal data, and that's data through which, of itself or in combination with other material, you can identify an individual. The GDPR sets out quite onerous obligations on organizations around what they do with personal data, but there is a subcategory of personal data for which the GDPR sets out additional safeguards. And that's sensitive data, which is referred to as special categories of data in the GDPR. And that's set out in Article 9. Biometric data is specifically included on the basis that it's defined under Article 4 14. You've got it there on the screen. It refers to personal data resulting from specific technical processing. That could be the template I talked about, which relates to the physical, physiological, or behavioral characteristics of a natural person. So, natural person, a living individual rather than a company, if that was ever to be possible, which allow or confirm the unique identification of that person, such as facial images or, and that means fingerprint data. That definition is drafted in very broad terms. It's supposed to be future-proof, or as future-proof as possible, but it envisages two types of biometric data: bodily characteristics, which would encompass a person's physical or physiological traits, and behavioral information, any behavioral characteristics that can be used as a unique identifier for a person. The use of type 1 data, the biometric data relating to bodily characteristics, is quite common now. We see fingerprint scanning, we see facial recognition, but type 2 data, behavioral identifiers, less common, and we're seeing it come along the tracks with some tech providers. Gait analysis, typing speed, mannerisms, stuff like that. If we go on to the next slide, so the GDPR covers biometric data. It's one of the special categories of data, added protections around its collection and use. As it's special category data, there are therefore certain conditions under which the GDPR set out must be met in order for the data controller to process the biometric data. And so there are standard lawful bases to process data that must apply. At least one of the following, I'll go through them. The data subject is given consent to the processing. The processing is necessary for the performance of a contract. The processing is necessary for compliance with a legal obligation. It's necessary in order to protect the vital interests of the data subject. It's necessary for the performance of a task in the public interest. It's necessary for the purposes of the legitimate interest pursued by the controller or by a third party. That's always the case for processing personal data, but one of the following additional bases must also be present. So you have to tick one of the boxes that we just set out, but then also, big long list, but you'll find it's quite restrictive in what you can actually do. So one of the additional categories has to be present. They are: data subject is given explicit consent to the processing. So explicit is a very difficult threshold to get over. Processing is necessary for the purposes of carrying out obligations and rights of the controller in the field of employment and social security and social protection law. Not really going to arise that often. It's necessary to protect the vital interests of the data subject. Not going to happen very often, and that's been translated as meaning life or death situations. Processing is carried out in the course of the legitimate activities of the controller with appropriate safeguards, where the controller is a foundation, association, or other not-for-profit body, and the specific conditions that apply. Again, very narrow. Processing relates to personal data which are manifestly made public by the data subject. Manifestly made public is something that's not defined, but let's consider it for a second. It can't be if you walk around in public, your face is in public, and therefore biometrics data relating to your face ticks that box. It's something different to that. It's, for example, you've posted your address online. Maybe your address has been manifestly made public. Stuff like that. Again, quite narrow. The establishment, exercise, or defense of legal claims. It's of a substantial public interest on the basis of union or member state law. It's necessary for the purposes of preventative or occupational medicine. It's necessary for the purposes of public health. It's necessary for archiving purposes in the public interest. These are all things that are very narrow. So there are very few of those conditions regarding special categories of personal data that controllers are often going to find apply. So we have very stringent requirements there in organizations that need to demonstrate why they have to process that data in order for it to be lawful. That initial threshold is going to be difficult. And this ongoing compliance with the GDPR is also going to be difficult after that point. If there is biometric data in relation to a data breach, that's going to be considered a significant breach by the Data Protection Supervisory Authority, the Information Commissioner's Office in the UK. And previously, the ICO, that's the UK's supervisory authority, has said that a security breach around sensitive data affecting even a single data subject could be considered serious enough to warrant a monetary penalty. when you consider that the monetary penalty regime under the GDPR has got massive financial penalties as being a maximum, up to 4% of annual global turnover, then this stuff obviously matters. On top of that, we've got PSD2. Frank, if you could move forward in the slides for me. PSD2, Payment Services Directive 2, another European Union piece of law. This acknowledges the rise of payment-related fintech companies, aims to create a level playing field for all payment services providers. It ensures enhanced security, it ensures strong customer protection. It enables bank customers, consumers and businesses to use third-party providers to manage the finances, amongst other things. So it suggests that in the near future you may be using Facebook or Google or a new player on the market in that sort of space to pay bills with. You can make peer-to-peer transfers. You can analyze your spending using third-party providers. And so that's revolutionary in some ways, but there are certain security and privacy concerns around that. And so what we have on the screen there is all payment service providers will have to apply strong customer authentication when the payer accesses payment accounts online, initiates an electronic payment transaction, or carries out any action through a channel that may imply a risk of payment fraud or other abuses. That's a way that the European Union is seeking to fetter the ability of the third-party providers to introduce a vulnerability into the payment services process. And an important element of this is two-factor authentication as part of strong customer authentication, which PSD2 talks about. Most consumers are aware of this, even if they don't know it by name. So when you have to input a username or password, that might not be considered secure enough. We often see additional steps. What's your mother's maiden name? Where did you go to school? Some of the questions that we leave with the banks are examples of multi-factor authentication. Moving on to the next slide there. Let's pause for a second. Halloween trivia. This is going to be a tricky one. Freddy Krueger came to life in what movie franchise? Is it A, Halloween, B, Friday the 13th, C, Nightmare on Elm Street, or D, Goosebumps? And again, email the answer to us. I'm getting a bit scared thinking about this one. Freddy Krueger played a large part in my childhood nightmares. Frank, next slide.
Thank you, David. So we're going to talk about litigation risk first on the U.S. side. Over the last 2 to 3 years, the number, as I mentioned, the number of class actions filed under the Illinois BIPA statute has skyrocketed. Now, the targets of these complaints range from small businesses and mom-and-pop shops to some of the largest companies in the world across a huge swath of industries, notably with the exception of the banking sector, which is statutorily exempted. I'll briefly discuss 3 of the pending lawsuits to highlight first the unsettled case law and second the enormous potential damages. So first up, we'll talk about the Six Flags case, which was filed in Illinois State Court. In this case, known as Rosenbach, the plaintiff is a minor who purchased, or presumably his parents purchased, a season pass to Six Flags amusement park. Six Flags scans the fingerprints of the season pass holder when he makes a purchase, and then instead of scanning a pass or handing in a ticket when the season pass holder arrives at the park, he simply scans his fingerprints to enter the park, thereby verifying his identity and tracking the number of times he visits. This also has the added benefit to Six Flags to prevent more than one person from using a single season pass. In any event, the minor season pass holder turned around and filed a putative class action against Six Flags, alleging that the park failed to get his consent to collect, store, and use his biometric data in the form, again, of his fingerprints. Now, this is state court, so Article 3 of the Constitution, which requires an injury to confer standing, doesn't apply. However, Six Flags successfully made a similar argument that the plaintiff was not a, quote, aggrieved person under the language of BIPA because he didn't suffer any harm as a result of the alleged violations of the statute. The plaintiff appealed to the Illinois Supreme Court, where the case remains pending, and oral argument is expected about the third week in November. Now, meanwhile, in a different Illinois appellate court, this one is in the first district, whereas the Six Flags decision was from the second appellate district. A different result was reached, and this is a very recent decision. The case is Sakura v. Krishna Schaumburg Tan, which is a putative class action brought by a member of a tanning salon. I didn't know that such a thing existed, but apparently you can become a member of a tanning salon. Similar to the Six Flags fact pattern, here the customer had a membership to a tanning salon. The members would, again, just like in Six Flags, scan their fingerprints every time they wanted to get in. Unlike in Rosenbach, in Sakura, this Illinois appellate court found that to satisfy the standard of aggrieved person under BIPA, the plaintiff only needed to allege the deprivation of a legal right, in this case, the statute itself. The court went even further, in fact, and found that the plaintiff could meet the standard by alleging a mental injury associated with the unconsented disclosure or storage of the fingerprint data. And that disclosure of the data to a third party, for example, by storing it on a cloud administered by a third party, could also satisfy the low threshold. And that's a very low threshold, one that even some of the bigger outliers in federal court would probably reject. So now the Illinois Supreme Court will decide Rosenbach, the Six Flags case, and potentially resolve the split between these two cases. The picture doesn't get much clearer in federal court, unfortunately. The most prominent BIPA case, at least in terms of headlines and potential damages, is against Facebook. And this case is actually venued in the Northern District of California as a result of a venue change that was made at the request and agreement of the parties. And note, this is not the only case venued outside of Illinois, and it is a somewhat open question as to the reach of BIPA beyond Illinois consumers. So unlike the majority of the recent BIPA putative class actions that have been filed, which typically involve what considered to be low-hanging fruit, so allegations of storage, collection, or use of fingerprint data without the consent of the consumer or the employee. On the other hand, the complaint against Facebook is a good indicator of where this sort of litigation could lead. The allegations in this case relate to Facebook's tagging feature. The plaintiffs are individuals who were tagged in other people's photos, and they allege that they did not give Facebook consent to collect, store, and use their likenesses, thus giving rise to BIPA claims. Now, the tag suggestion feature works in 4 steps. The software tries to detect the faces in uploaded photos. Once detected, Facebook computes a face signature, a series of numbers that represents a particular image of a face based on your photo, and a face template database that the system uses to search face signatures for a match. If the face signature matches, Facebook then suggests the tag. Facebook doesn't store the face signatures, it only keeps the face templates. Now, most significantly, for our purposes, the plaintiffs did not allege, jump the gun a little bit, the plaintiffs did not allege that they suffered any independent injury or concrete harm as a result of the BIPA violations. But the court nevertheless afforded them Article 3 standing since it held that the Illinois legislature had, quote, codified a right of privacy in personal biometric information. The court pointed to the language of BIPA, which focused on protecting the right of individuals to protect their unique and inherent personally identifiable information, and it concluded that a violation of that right is, quote, quintessentially an intangible harm that constitutes a concrete injury in fact, thus satisfying the Article 3 standard. In re, Facebook is significant for 2 other reasons. First, the court noted that, quote, BIPA expressly recognizes that Social Security numbers do not implicate the kind of privacy concerns that biometric identifiers do. And so holding, the court distinguished biometric suits from the hundreds of data breach class actions filed every year that allege impending threat of future harm based on exposed or stolen Social Security numbers. Second, the the court distinguished the allegations in this case from some other notable BIPA decisions because in this case the plaintiffs did not know their data was being collected. Again, it was other people's photos, and therefore they did not implicitly consent to its collection by virtue of their use of Facebook's services. This is not the only federal court to find similarly, and federal cases against Shutterfly and Google, both also involving facial recognition technology, also survived motion to dismiss challenges. Now, just a month after this decision was issued in April, the Northern District of California certified the Facebook class action. Given the statutory damages available under BIPA and the number of class members, the potential damages in this case easily reach into the billions of dollars. Facebook filed an interlocutory appeal of the class certification order, and the case has stayed pending a decision on that appeal from the Ninth Circuit. So these cases that we just talked about in federal and state court highlight the various standards courts have applied to at the pleading stage. There may be some clarity once the Illinois Supreme Court and Ninth Circuit weigh in, but for anyone who has followed the Spokio line of cases or data privacy class action jurisprudence, like in the Attias v. CareFirst case out of the D.C. Circuit, there are no guarantees that this area of law will be resolved anytime soon. And this is particularly true at the federal court level, as the overwhelming majority of these cases are not filed in the Ninth Circuit, but in courts in the Seventh Circuit. Now, generally speaking, the case law on BIPA is undeveloped. While there have been waves of these claims filed, primarily in state and federal court in Illinois, it's unclear as to how successful they can be, and therefore the picture is blurry as to how much they should settle for example. So all those decisions arise from BIPA, the Illinois statute, that remains the only statute on the books that provides for a private right of action in these circumstances. There are other statutes that have been enacted that resemble BIPA, first in Texas and then in Washington, but neither provide for a private right of action. Other states have considered but have not enacted such laws, at least not yet. Some examples are Michigan, New York, Alaska, New Jersey, and Montana. New Hampshire's legislature created a committee tasked with determining the appropriate level of regulation of biometric data, and their report and findings are due next month. Some states, including Delaware, have explicitly incorporated biometrics protections into their breach notification laws, although in that state, a private right of action is not yet available. Vermont has enacted a law governing the process of regulating third-party data brokers, and that law specifically defines personal information to include biometrics. The Vermont law does not apply to first-party holders of biometric data, at least not yet, and there's a chance it will be amended or a separate law will be enacted. The current Vermont law does provide for a private right of action, but again, only against third-party data brokers. I'll point out that California's Consumer Privacy Act of 2018, which confusingly goes into effect in January of 2020, and which has been compared by many experts to the GDPR, does specifically address biometric data. But it also provides an exemption for encrypted data, which would encompass much of the biometric data that companies use, as we've been explaining. Specifically under that statute, personal information does not include information that has been, quote, de-identified, which prevents it from being reasonably linked to a particular person. That law will allow a private right of action under certain circumstances. And for more on the California Consumer Privacy Act, we encourage you to check out the webcast our colleagues will be giving next week, next Wednesday, October 24th. So beyond these laws and potential laws, there are also statutes relating to the collection and use of biometrics for students in a number of states. And there are laws in a few other states that apply to the collection of biometric information by government actors. And finally, there has been some debate and even some proposals from state legislatures in Illinois to narrow the language and the applicability of BIPA, nothing with any real traction yet. Finally, with respect to federal law, there currently are no biometric-specific laws on the books. The FTC passed guidelines in 2012, which they could theoretically enforce under Section 5. And it's also worth mentioning that the FTC has the authority to enforce the provisions of the Fair Credit Reporting Act when any information, including biometric information, is used to determine eligibility for credit, insurance, or employment. And this could become more important if biometric data is used to blacklist certain consumers or segment the advertising shown to them. Time for another trivia question. Which TV show airs a Halloween-themed episode each year titled Treehouse of Horrors? The Simpsons, Will and Grace, Law and Order SVU, or This Is Us? And with that, I'll turn it back over to David.
So with those quiz questions, you guys are really keen. We're getting some answers put in the chat box as part of the presentation. In order to be eligible for the prize, please email those answers to us after the webcast is finished in a single email, and we'll see what we can do in terms of prizes. Very exciting prizes on offer as well. So in terms of the European position then, let's consider the climate that we're in. And this climate is not a European-specific one, but we'll bring in the European law. So the climate is this. Systems are set up now to refer to security features based on, for example, passwords, mother's maiden name, home address, date of birth, school, first pet. All of those things are either publicly known pieces of information because it's something about you like your address which people can look up, because people put it online on Facebook or other social media channels, or because, and especially with respect to social security numbers and passwords, those things are becoming fairly routinely lost as part of data breaches. That climate then is one that's driving towards more creative and, if there is such a thing without it being an oxymoron, more secure ways of having security measures. Passwords being the historic way of identifying somebody as being able to access information is no longer secure in an age in which passwords are routinely lost as part of data breaches, are routinely reused, and something which consumers and members of the public find very difficult to do in a unique way without putting password 1, next time password 2, next time password 3. So there is a vulnerability in general around online services. PSD2, European legislation, tries to push back on that. It mandates secure customer authentication on the basis that it believes that secure customer authentication is a proportionate way to deal with this very issue. Secure customer authentication, two-factor authentication, let's consider what it is for a minute. It's authentication based on the use of 2 or more elements, categorized as, and there are 3 different possibilities: knowledge, something the user knows; possession, something the user possesses; or inherence, something the user is. So something the user knows, possesses, or is. You have to choose 2 or more elements. Now, something only the user knows is going to be a password of some sort, and that could include address, date of birth, all of the mundane stuff that we hear about, which I think is becoming insecure. Possesses, or something the user is. We're driving towards biometrics there. And let's think back to what we covered in the earlier slide about PSD2. All of these great features of third parties being able to access bank accounts and payment services is one that's predicated on being able to do so securely by way of secure customer authentication. The future may not be one in which high street banks are the predominant providers of banking services. The future may be that they are. But whatever the future is going to be one that requires secure customer authentication, and that's driving increasingly towards biometrics because of its ease of use, because of its protections for the payment services provider, but also because of its protections of the consumer. That gives one half of the story. The other half of the story is the GDPR. And what we've got on screen there is the pitfalls that goes wrong. But rowing back a second, the GDPR provides for very stringent conditions around when an organization can use biometric data. There are very difficult barriers to get over before an organization, in its guise as a data controller, can use biometric information. What if it goes wrong? So what if an organization decides we want to do this securely because it's good? It's a good thing for everybody. We want to do it securely because PSD2 says we've got to. We can tick that box. And then thirdly, what does the GDPR say? The GDPR part is where organizations are going to get into trouble. And if it goes wrong, we've got, of course, if it goes wrong, 4% of annual global turnover being a maximum fine that the supervisory authority can impose, the regulator in the UK, the Information Commissioner's Office. But there is also this part here, which is interesting and which we're seeing. So Frank's spoken about class action, and that's something that in the US you guys are much more familiar with. In the UK and in Europe, we're seeing a burgeoning class action atmosphere, and that's often by way of group litigation orders, which is the way that is provided for in the UK. So Article 82.1 and Article 81 there, let's read it together. 82.1, any person who has suffered material or non-material damage as a result of infringement of this regulation shall have the right to receive compensation from the controller or the processor for the damage suffered. What does it mean? Any person who has suffered material or non-material damage, so that's referring to quantifiable damage, that's referring to financial loss, material. Non-material damage is the opposite. What this translates into is an ability to claim for compensation for distress. A distress-based compensation culture is what we think we're going to see under the GDPR, although that is yet to be seen. So in the past, under our previous law, the Data Protection Act 1998 was the UK way of transposing the European Data Protection Directive. And what the directive and the Data Protection Act allowed for was, translated by the courts into allowing for, was compensation claims on the basis of loss. If you had lost money or if you had some quantifiable loss, you could claim compensation for that, and often you get distress-based claim as part of that. But you could not claim for distress alone. And as the GDPR was on the rails, as it was coming into the station, the UK court started to change its position on that. And a case involving our old friends Google, we had the courts in the UK allow distress-based compensation claims pre-GDPR. The GDPR came in, and what we see there in that Article 82.1 in that fairly opaque language is an acknowledgement any person who has suffered material or non-material damage, i.e. distress, can claim compensation. The next part of that article, and this is European legislation, so it's difficult to follow and it's difficult to break down, which is why I'm labouring over it, but it says right to receive compensation from the controller or the processor for the damage suffered. What does it mean? What it allows for is a data subject, if they think they've been wronged, can claim the party that they think has got the deepest pockets. If there is a controller in there, and if there is a processor in there who is a service provider who's doing something further down the channel, and I say channel in a metaphorical and literal sense, in this situation, a payment service provider has lots of people within that chain. Any of them can be sued there under the GDPR, under this article. And a separate article says it should be apportioned between the parties as to who is ultimately to blame. But this article allows for the processor to be sued even if it's the controller's fault. And the other article says you can claim between yourselves, but the ultimate thing is the data subject gets their compensation. The focus of this is the data subjects getting their compensation if it's gone wrong. This is a change in Europe, and this is a change. It might not raise eyebrows on the other side of the Atlantic, but this is a change here. And the next part, the data subject, this is under Article 81, the data subject shall have the right to mandate a not-for-profit body, organization, or association to exercise the right to receive compensation. This is driving towards privacy groups, civil rights groups. It's driving towards class action in a very real sense to be able to claim if there's harm or if there's perceived harm as a result of issues to do with biometric data under the GDPR. What does that mean? And in a lot of the examples that Frank has drawn out, and a lot of the examples I know about from the US, that tends to be where there's a breach, where there's a hack, or it's often a breach where there's a hack. What the GDPR is doing here, though, is giving very stringent conditions on an organization. If they want to use biometrics, there are lots of boxes to tick, and there are difficult boxes to tick. If they don't tick those boxes, that is an infringement of the regulation, and Article 821 says any person who has suffered distress even. So, are you upset? Yes, I am. During the queue. Any person who has suffered non-material damage or material damage as a result of an infringement of the regulation shall have the right to receive compensation. That is the sword of Damocles hanging over the head of any payment services provider who wants to use biometrics in Europe, and that's a problem. And so what we have there is an irreconcilable difference between what PSD2 is driving towards, security by way of strong customer authentication, i.e. biometrics, what culture is driving towards, passwords becoming less and less useful over time, and on the other hand, what the GDPR says. What the GDPR says in its legislative terms, but also in terms of the compensation aspect. And this is a problem. And we don't know what the answer is because, of course, European Court of Justice, Article 29 Working Party, European Data Protection Board have not given very prescriptive answers as to that. But what we are seeing is clients asking us the question, clients who are asking us to think up, to draw up frameworks which will straddle both PSD2 and the GDPR in order that they can do something that ticks both boxes at the same time. And it's not easy, but it's something that we're going to see more and more of across organizations who want to exist and coexist between the US and EU and the UK. Frank, next slide.
Yeah, David, I'm just going to jump in real quick for housekeeping
Absolutely.
matters. If you're interested in receiving CLE credit for today's presentation, there's a space for your confirmation code. As you may have noticed, David is from Liverpool, and in his honor, the confirmation code today is RINGO, R-I-N-G-O. RINGO is the CLE confirmation code. And back to David.
Okay. Roadmap to compliance. Look, we can't give you the answers because it's not going to be a one-size-fits-all thing. What we have, though, is a very broad, high-level idea of how this is going to work. What we've done here is track the language of BIPA: collection, use, storage, consent, consent, consent. Align both jurisdictional regimes. Now, the GDPR talks about it in these terms, broadly speaking, as well. So when the data is collected, there are very specific things that organizations have got to do. There are transparency principles and accountability principles. That means that when the data is collected, the data controller must tick the box, I have taken the data because, and the lawful bases that we saw before, those two columns that I referred to, stuff that refers to personal data collection in a general sense, and stuff that refers to it as a special category of data being biometrics. That stuff must be understood upfront by the data controller, who must deliver that information to the data subject by way of a document of some sort, and a privacy notice is the way it's done. Collection of the data must be lawful from the outset, otherwise the processing will be unlawful ab initio. And to those who aren't Latin scholars, that means from the outset. Use of the data, you've got to stay true to what you've said. If you said you're going to use the data for one purpose and you then think, well, this fingerprint data might be useful for something else as well, let's use it for that. Well, that wouldn't be compliant. The use of the data has got to stay true to what you've said. It's got to remain compliant throughout. This life cycle of the data that we've got on the screen is something that a regulator within Europe can and will and should ask for. You must be able to document that. Accountability principle of the GDPR, core principle, you've got to not only be compliant, you've got to be able to demonstrate compliance. And the way you demonstrate compliance is by being able to document and produce the documentation that evidences you tick in these boxes. Collection, use, storage, store that data in a secure way. The start of this, we spoke about that Apple chip, which stored the biometrics data on the device itself. Crucial point, and whether Apple's secure in that or not, the principle is certainly a good one. But that data's got to be maybe kept separate, it's got to be encrypted, maybe it's got to be hashed and salted, it's got to be a different level of security because one, it's special category data, and two, if it goes wrong on your head B, you know what the GDPR fines are. And the last point there, consent. Consent isn't the only way that you're going to be able to use biometric data under the GDPR, but going back to the list I referred to, explicit consent is one way in which you can do it. Now, if you use that explicit consent, you've got to stay true to that consent. If the customer withdraws, or the consumer, or the data subject withdraws the consent, you've got to think about whether you can continue to lawfully hold the data. Consent is a cornerstone part of the GDPR in terms of being able to respect the data subject's rights. Not everything's about consent, but in terms of biometric data, I think more often than not it's going to be consent-based processing. Those 4 arrow pathways there broadly aligns with what BIPA says. Frank, do you have any concluding parts about this slide? BIPA's your baby.
Yeah. Sure. One thing I would note quickly on BIPA is that no manner of consent, no type of consent will cover another BIPA part. That is, you cannot profit from the use of the biometric data that you collect from individuals. So you can't even get consent around that prohibition. We've got one last Halloween trivia question. Season 2 of Netflix, what Netflix series takes place on Halloween? A, Orange is the New Black, B, Jessica Jones, C, House of Cards, or D, Stranger Things? So we've obviously covered a lot of ground here today at a high level and haven't been able to provide you with the type of granular level specificity as to each and every aspect of biometrics that will apply to you or your business. But we're happy to answer any questions over email or phone, and please keep an eye out for future webcasts, articles, other presentations on biometrics. The software is developing rapidly. The law is slow to catch up as usual, but it is moving. So this is an important area to keep an eye on in the coming months and years. Note that this presentation and the slides will be available on our website following the conclusion of today's webcast. And if you have any trouble accessing that, feel free to reach out to either of us. With that, we are out of time. So thank you for joining us today, and we hope to do something like this again in the near future, hopefully more targeted to meet your requests and questions. Thank you very much. David, thank you for joining me from the UK, and we'll turn it back over to the TalkPoint vendor to conclude.
Thank you.
Thank you. Thank you. This concludes today's teleconference. You may disconnect your lines at this time. Thank you for your participation and have a wonderful day.